I know, Lord of mercy, light my pathway, make me whole. Just a closer walk with thee, 'cause your love will make the difference in me. In me, there's no place I'd rather be than beneath your wings of serenity. I'm so prone to stray. Hold me tightly, don't let go. Shepherd, lead me, guide me daily. I am yours. Just a closer walk with thee, for your love will make the difference in me. Oh, there's no place I'd rather be than beneath your wings of serenity. Oh, sound like your own now. Every step I take, closer and closer and closer and closer. When you hear it sound like your only set me, there is sorrow, quiet calm that manage without you, yeah. Without you, without you.
Greetings, 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 greetings. I'm King Clifford Jefferson, a son of Godfrey, the fifth kind of man Jew, son of fourth ruler of Jerusalem. I'm the reincarnation of King Edgar the Peaceful, which we know here as the Vicar of Christ or Jesus Christ. It is August the 30th, 2025, would be equivalent to the birth year 2975. I greet you in the name of all those who are striving to get an understanding about the truth. This is part three. Part three. Proof of the revolutionary breach of the Crown legal continuity. Part three. Proof of the revolutionary breach of the Crown's legal continuity. When I say proof, of the revolutionary breach of the Crown's legal continuity. I actually mean what I'm saying. The part one, part two was proof, but here's the concrete proof of what part one and part two was actually trying to say. We'll get started in just a few seconds. Not gonna hold you long this evening. So I got to get a couple of more viewers than I usually have. And I do the lectures in the afternoon. Nonetheless, the show must go on. Part three, proof of the revolutionary breach of the Crown's legal continuity. Right? Put this one in history. Like, share, subscribe, leave your comments in the chat box, and I try to get to them if I can, as well as donate free and common tokens to those who are able to, based upon the obligation and allegiance, based upon the promise of the inheritance that we're going to go over again and again and again and again until the brothers and sisters, the heirs, the grantees get it right. Okay. Just going over some brief points real quick before we get started. Part three, proof of the revolutionary breach of the legal continuity of the Crown of England. Revolutionary breach of legal continuity. Let's define that again, just in case those have not caught it. Revolutionary breach of legal continuity is the concept of the English constitutional law which rationalizes the historic English behavior when one king or regime was disposed and a de facto ruler was recognized as the new jure minor or Republican authority. Or generally, it is any process unauthorized by any existing legal order which results in the creation of a new legal order, whether or not the revolutionary change is brought about by violence. A technical breach of the continuity might happen when the former constitutional arrangement is so inefficient that there is not even a practical legal way to amend it. You hear that word, that term, amend. Hence the 14th Amendment. Okay, hence the Reconstruction Amendments. Okay, the 14th Amendment was part of the Reconstruction Amendments. Okay, for the emancipated slave, not black people, not Africans, but the emancipated slave, the free man. I'm telling you, those emancipated slaves, those free men, were in fact English. Okay. The most recent example that one can give in regards to the revolutionary breach of a legal continuity is that of the United States Declaration of Independence. It had no basis in the previous legal order, which had governed the original 13 colonies and represented the start of a new legal order. A few years later, the replacement of the Articles of Confederation with the United States Constitution was a technical breach of continuity, which did not result in a civil war, only because of the very reason of the breach. The United States, under the Articles, had a weak central government that therefore had no means to defend itself. Okay? Very important that we get that out the way. Let's get to the 14th Amendment. Those who watch the prior lectures, I already know what the 14th Amendment and the sections recommend. Most important section of all sections of the 14th Amendment is Section 1. All persons born or naturalized in the United States and subject to the jurisdiction thereof, and are citizens of the United States and of the states wherein they reside. No state shall make or enforce any law which shall abridge the privileges or amenities of a citizen of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within this jurisdiction the equal protection of that law. Okay? Section 2 goes into those who are entrusted with that obligation. It's the representatives. A state shall be apportioned among the several states according to their respective numbers, counting the whole of the person in each state, excluding Indians not taxed. When the right to vote of any election for the choice of electors for president and vice president of the United States, representatives in Congress, the executive, judicial officers of a state, or the members of the legislature thereof, is denied to any of the male inhabitants of such a state, being 21 years of age and a citizen of the United States, or in any way, abridged except for participation in rebellion or other crimes, the basis of representation there should be reduced in the proportion which the number of such male citizens should bear to the whole number of male citizens 21 years of age in such state. Okay, that's a preliminary understanding that we must have in regards to today's lessons in lieu of part 1 and part 2. The latter being part 3, which is being done today. Okay. Section 3 deals with Congress. The person should be a senator or representative in Congress, very important, or elector of president and vice president, or hold any office, civil, military, under the United States, or under any state who having previously taken to an oath as a member of Congress, or as an officer of the United States, or as a member of any state legislature. Very important. The argument tonight is going to be the state legislator, or as any executive or judicial officer of any state. To support the Constitution of the United States shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof by Congress made by a vote of 2/3 of each house, remove such a disability. Okay? That's very important in regards to the 14th Amendment and its sections. Section 1, Section 2, Section 3, Section 4, and Section 5. Section 1 deals with the life, liberty, and property, and the due process of law that's there to protect that property. Read it and weep, brothers and sisters. Okay? Now let's get to the meat. We've been through this in part 1, part 2, part 3. So I'm not going to reiterate what I said in part 1, part 2, and part 3. In part 1 and part 2. All right. So if you want to know what I learned in part 1 and part 2, you have to go back and watch those videos. In part 3, here is the concrete proof of what I was saying in part 1 and part 2. Okay. Let's go to it. And I'm going to reference what we talked about in part 1 and part 2 to qualify the proof we got in part 3. Okay. Straight to it. So I'm not going to hold you long tonight. Let's get into the evidence. If there's any questions in the chat, let me know. If there's any questions in the chat, post them. Reconstruction Amendment. Let's look at the word Reconstruction and amendments. Reconstruction means exactly what it says. To rebuild. Okay? Reconstruction means to reconstruct, to start from the bottom to the top. Okay? Point and simple. Amendment means to change, to amend, to correct. And the prefix meant, amendment means to solidify or to make sure or to qualify that what you amended was in fact correct, based upon the reconstruction, the rebuilding. Okay? The Reconstruction Amendments or the Civil War Amendments are the 13th, 14th, 15th Amendments to the United States Constitution, adopted between 1865 and 1870. The amendments were a part of the implementation of the Reconstruction of the American South, which occurred after the Civil War. Okay? The 13th Amendment proposed in 1864 and ratified in 1865 abolished slavery and involuntary servitude, except for those duly convicted of crime. This goes into the Fifth Amendment. The 14th Amendment proposed in 1866, key date, 1866, and ratified in 1868, addressed citizenship rights and equal protection of the law for all persons, and this include that this all persons are those who were emancipated from slavery, okay, inclusively and exclusively, and prohibiting discrimination and voting rights of citizens on the basis of race, color, and previous conditions of servitude, okay, of race and color or previous condition of servitude. Getting to the amendments. The 13th Amendment. Under the 14th Amendment is where our freedom came, brothers and sisters, as free men. Because according to the 13th Amendment, we were still in slavery and then emancipated as a result of that. So prior to Article 1 through 7 and all the amendments that originated from Article 1 through 7, all the way up to the 13th Amendment, is the amendment that emancipated slavery. The 13th Amendment to the United States Constitution abolished slavery and involuntary servitude, except for punishment of a crime. It was passed by the United States Senate on April 8th, 1864. Majority of us already know that, okay? Majority of us already know that, so that's nothing new, okay? Slavery had been tacitly enshrined in the original Constitution through provisions of such as Article 1, Section 2, Clause 3, commonly known as the Three-Fifths Compromise, which detailed how each state total enslaved population would be factored into its total population count for the purpose of apportioning seats in the United States House Representatives and direct taxes among the states. Although many enslaved people have been declared free by Lincoln through the 1863 Emancipation Proclamation, their legal status after the Civil War was still uncertain. Okay, key. The 14th Amendment. The 14th Amendment to the United States Constitution was proposed by Congress, not ratified, proposed June 13, 1866. By July 9th, 1868, it had received ratification by the legislature of the required number of states in order to officially become the 14th Amendment. We're talking about the United States, brothers and sisters, ratifying the 14th Amendment when it was presented or proposed in 1866. Okay? Very important date, 1866 and 1865, right? So we understand that once we're emancipated, the proposal for the protection of the first section of the 14th Amendment, based upon the second section, based upon the representation in regard to those who were appointed, based upon the proportionment of what we call Act, the Apportionment Act, based upon the citizens, which we removed this stigmatization of three-fifths of a person. Okay, we were no longer considered three-fifths of a person, but we still had no right of suffrage, as those equated to what we call free men. Okay, very important. Amendment addressed citizenship right and equal protection of the laws and were proposed in response to issues related to the treatment of freemen following the war. Key point. So with that understood, let's go to the proof. All right. I said this is the proof. All right. How many of you know what a joint resolution is? Let's look at that first. Let's define joint resolution first. Make sure we know what we're talking about when we talk about it. Joint resolution. In the United States Congress, a joint resolution is a legislative measure that requires passage by the Senate and the House of Representatives and is presented to the President for their approval or disapproval. Generally, there is no legal difference between a joint resolution and a bill. Both must be passed exactly the same form by both chambers of the Congress and signed by the President or repassed and override of the presidential veto, or remain unsigned for 10 days while Congress is in session to become law. Only joint resolutions may be used to propose amendments to the United States Constitution and its amendments, and these do not require the approval of the President. Laws enacted by joint resolution are not distinguished from laws enacted by bills, except that they are designated as resolution as opposed to what? Acts of Congress. Acts of Congress. With that being said, let's take a look at the joint resolution presented by the legislature of New Jersey in regards to the withdrawing the 14th Amendment that was ratified and proposed by a New Jersey state legislator, which speaks on behalf of what we call the United States. Okay? Let's see it for ourselves. I said I was going to bring the proof. This is the proof. And we're going to see the result of what the another joint resolution proposed by the legislator had to say about the joint resolution on behalf of the state legislator, which was based upon people in the same house. So this is a internal fight in the House in regards to the implementation of the 14th Amendment. Okay, This is very important for us to understand the implementation of the 14th Amendment and to who it was being implemented for. Okay? The proof is right here. The Senate, Joint Resolution Number 1, State of New Jersey. Joint resolution withdrawing the consent of the state to the proposed amendment to the Constitution of the United States, entitled Article 14, and rescinding the joint resolution approved September 11th and Los Dominios 866, whereby it was resolved that the said proposed amendment was ratified by the legislature of the state. So this is a joint resolution by the legislator to withdraw the recommended proposed amendment and the ratified amendment of 1866 and 1866 and 1868. The legislative branch proposed this joint resolution to withdraw the proposed amendment to the Constitution of the United States entitled the 14th Amendment. They wanted to rescind it, brothers and sisters. Let's look at it. This is in 1868, I might add. This joint resolution came about in 1868. Okay? 1868. All right, so I'm reading this part. The legislature of the state of New Jersey, having seriously and deliberately considered the present situation. Oh, I got to go back for this. This is really good. And yes, this is going in the appeal. I just found this today. In lieu of what we spoke about in part 1 and part 2, part 3, the proof, I found this today. Okay? This was actually found today. The legislature said, all right, so said by whereby it was resolved that the said proposed amendment was ratified by the legislature of the state. The legislature of the state of New Jersey, having seriously and deliberately considered the present situation of the United States, do declare and make known that the basis of all government is the consent of the governed, and all constitutions are contracts between the parties bound thereby, and that until any proposition to alter the fundamental law to which all the states have consented has been ratified by such number of the states as by the federal constitution, makes it binding upon all, anyone that has assented it as a liberty to withdraw that assent, it becomes its duty to do so. When upon mature consideration, such withdrawal seems to be necessary to the safety and happiness of all. Prudence dictates that the consent once given should not be recalled for light and transient causes. But the right is a natural right, the exercise of which is accompanied with no injustice to any of the parties. It has therefore been universally recognized as inherent in every part and it has ever been left unimpaired by any positive regulation. The said proposed amendment, i.e. the 14th Amendment, not yet having received, okay, not yet having received the said proposed amendment not yet received the assent of the 3/4 of the states, which is necessary to make it valid. So once again, when the joint resolution that we're reading now was proposed, it was before the ratification of the 14th Amendment. They created this joint resolution to withdraw from the ratifying of the 14th Amendment that was proposed in 1866. Okay? Very important that you understand this in lieu of this argument. The said proposed amendment not yet having received the assent of the 3/4 of the states, which is necessary to make it valid, the natural and constitutional right of the state to withdraw its assent is undeniable. Okay, so based upon it wasn't ratified yet, the right to withdraw under the proposed and ratified 14th Amendment, which wasn't law yet because it didn't become law till 1868. Okay, they presented the joint resolution before the ratification because it just said it wasn't made valid yet. With this impression and with a solemn appeal to the searchers of all hearts for the rectitude of our intentions and under the conviction that the origin and object of said proposed amendment were unseemly and unjust, and that the necessary result of its adoption must be to the disturbance of the harmony, and if not, the destruction of our system of self-government, and that it is our duty to ourselves and our sister states to expose the same, do further declare that it be necessary by the Constitution that every amendment to the same should be proposed by 2/3 of both houses of the Congress. The author of the said proposition, for the purpose of securing the assent of the requisite majority, determined to exclude from the said two houses 80 representatives from 11 states of the Union upon the pretense that there were no such states in the Union, but finding that 2/3 of the remainder of the said houses could not be brought to assent to that said proposition, they deliberately formed and carried out the design of mutilating the integrity of the United States Senate, and without any pretext or justification other than the possession of the power without the right, it is palpable violation of the Constitution. Ejected a member of their own body representing the state, and thus practically denied to New Jersey its equal suffrage in the Senate, and thereby nominally secured the vote of 2/3 of the said houses. The object of dismembering the highest representative assembly in the nation and humiliating the state of the Union, faithful at all times to all its obligations, and the object of said amendment were: 1, to place a new unheard of power in the hands of a faction that it might absorb to all executive, judicial, and legislative power necessary to secure for itself immunity for the unconstitutional acts it had already committed and those it had since inflicted on the two patient people. Once again, I repeat, the object of dismembering the highest representative assembly in the nation and humiliating the state of the Union, faithful at all times to all its obligations and objects of the said amendments, were: 1, to place new and unheard powers in the hands of a faction that it might absorb to itself all executive, judicial, and legislative power necessary to secure for itself immunity from the unconstitutional acts it had already committed and those it had since inflicted on two patient people. This is called the Reconstruction Amendments. They're fiction, but they have broken. Okay? They restore the executive, judicial, legislative power under the common law of England as prescribed in 1702, when it was called His Majesty's Council. Okay? Very important. The 14th Amendment was a reconstruction of the former government, starting from the bottom to the top. This is why the legislative members who enacted this joint resolution had a problem with the legislative members who opposed this joint resolution. Does this make sense to anybody, brothers and sisters? The subsequent usurpation of these one national assemblies and passing pretended laws for the establishment in 10 states of martial law which is nothing but the will of the military commander, and therefore inconsistent with the very nature of all laws, for the purpose of reducing to slavery men of their own race in those states, or compelling them, contrary to their own conviction, to exercise the elective franchise in obedience to the dictation of a faction and those assemblies. The attempt to commit to one man arbitrary and uncontrollable power, which they had found necessary to exercise, to force the people of those states into compliance with their will. The authority given to the Secretary of War to use the name of the president to countermand the president's orders is to certify military orders to be by the direction of the president, when they are notoriously known to be contrary to the president's direction, thus keeping up to the forms of the Constitution. See, what they are upset is that the president we have now is not going by the script that the previous president were going by prior to the creation of the 14th Amendment. This is the problem they have with Executive Order 14160. Okay, in lieu of the parameters of the 14th Amendment, Section 1, Section 2, Section 3, Section 4, and Section 5. It says, and I continue, presidents, when they are notoriously known to be contrary to the president's direction, thus keeping up the forms of the Constitution to which the people are accustomed. See, they were accustomed to the actions of the president under the former government prior to the actions of the 14th Amendment and the new administration that was reconstructed and amended to make it correct, because you know it was correct based upon its foundation, because it said it was what? A weak government, okay? It was a weak government. That is of the executive, the attempt to withdraw from the Supreme Judicial Tribunal of the nation the jurisdiction to examine and decide upon the conformity of their pretended laws to the Constitution, which was the chief function of that august tribunal, as organized by the fathers of the Republic. All by the fathers of the Republic. All are but amplified explanations of the power they hope to acquire by the adoption of said amendment. To conceal from the people the immense alteration of the fundamental law they intended to accomplish by the said amendments. See, now they realize that the law that they was going by was assumed to be fundamental. It was not fundamental. Okay, so now they are upset about the people who are in the position to change the law by changing the legislation in favor of that exclusive, inclusive group of individuals known as the free slaves, okay? Prior to that 14th Amendment, Reconstruction Amendment, the 13th Amendment, which emancipated us, we were slaves. So the legislature didn't have a problem with that, because as soon as we tried to run, we were brought back as a result of the taking clause, the Fifth Amendment. So it said it proposes to make it a part of the Constitution of the United States, i.e., the original 7 articles and the 1 through the 13th Amendment. That's the original Constitution for them. The amendment to that Constitution, that Constitution, i.e., the 14th Amendment, is the new Constitution, is the Reconstruction, is a new foundation for which all English people should be standing on. It said it proposes to make it a part of the Constitution of the United States that naturalized citizens of the United States should be citizens of the United States as if they were not so without such absurd declaration. It lodges with the legislative branch of the government the power of pardon, which properly belongs by our system to the executive branch. You hear that? It denounces and inflicts punishment for past offenses by constitutional provisions, and thus would make the whole people of this great nation in the most solemn and sovereign act guilty of violating a cardinal principle of the American liberty, that no punishment can be inflicted by any offense unless it is provided by law before the commission of the offense. It usurps the power of punishment, which in any coherent system of government belongs to the judiciary, and it commits to the people in their sovereign capacity. So they got a problem with the restoration of the fusion of government of the executive, legislative, and judicial branch. They just said it in the joint resolution in which the legislative branch who presented the joint resolution is going to strike it down. Okay? They're going to strike it down. I said I was going to bring the proof. Here's the proof. It degrades the nation by proclaiming to the world that no confidence can be placed in its honesty or morality. It appeals to the fears of the public creditors by publishing a label on the American people and fixing it forever in the national constitution as a stigma upon the present generation that there must be constitutional guards against a repudiation of the public debt, as if it were possible that a people who were so corrupt as to disregard such an obligation will be bound by any contract, constitutional or otherwise. It imposes new prohibition upon the power of the state to pass laws and interdicts the execution of such parts of the common law as the national judiciary may esteem inconsistent with the vague provisions of the said amendment, made vague for the purpose of facilitating encroachment upon the lives, liberties, and property of the people. Okay? I repeat, it imposes new prohibitions upon the powers of the states to pass laws and interdicts the execution of such parts of the common law as the national judiciary may esteem inconsistent with the vague provision of the said amendment, made vague for the purpose of facilitating encroachment upon the lives, liberties, and property of the people. And enlarge the judicial power of the United States so as to bring every law passed by the state and every principle of the common law relating to life, liberty, or property within the jurisdiction of the federal tribunal and charges those tribunals with duties to the due performances of which they, from their nature and organization and their existence from the people, are unequal. Okay? You're not equal with the people. Why? Because the people are, in fact, sovereign. Let's continue. Let's continue. It makes a new apportionment of representation in the National Council for no other reason than thereby to secure to a faction a sufficient number of the votes of a severe and ignorant race to overweight the intelligent voice of their own. This is unbelievable. Once again, it makes a new apportionment of representation in the National Council for no other reason than thereby to secure to a faction a sufficient number of the votes of a servile and ignorant race to outweigh the intelligent voices of their own. It sets up a standard of suffrage dependent entirely upon citizenship majority, inhabitancy, and manhood, and any interference whatsoever by the state imposing any other reasonable qualification as time of an inhabitancy causes a reduction of the state's representation. But the demand of the supporters of this amendment in the state that Congress should compel the people of New Jersey to adopt was to adopt what is called an impartial suffrage makes it apparent that this section was intended to transfer to Congress the whole control of the right of suffrage in the state for itself and to deprive the state of a free representation by destroying the power of regulating suffrage within its own limits, a power which they have never been willing to surrender to the general government and which was reserved to the state as a fundamental principle on which the Constitution itself was constructed. The principles of self-government, this section, as well as all others of the amendment, is couched in an ambiguous, vague, and obscure language. The uniform resort of those who seek to encroach upon public liberty strictly construed is dispensed entirely with a House of Representatives unless the state shall abrogate every qualification, especially that of time of inhabitancy, without which the right of suffrage is worthless. this legislator feeling conscious of the support of the largest majority of the people that had even given expression to the public will, declare that the said proposed amendment being designed to confer or to compel the state to confer the sovereign right of the elective franchise upon a race which has never given the slightest evidence at any time or in any quarter of the globe of its capacity for self-government, and erected an impractical standard of suffrage which will render the right valueless to any portion of people, was intended to overthrow the system of self-government under which the people of the United States have for 80 years enjoyed their liberties and is unfit from its point 7 has enjoyed their liberties and is unfit from its origin. Its object is its matters to be incorporated with the fundamental laws of a free people. Therefore, 1, it be resolved by the Senate General Assembly of the state of New Jersey that the joint resolution approved September 11th, Annus Dominios 1866, related to the amending the Constitution of the United States, which is following words, to which joint resolution ratifying the amendment of the Constitution of the United States. 1, be it resolved by the Senate and General Assembly, all right, this is you talking, of the state of New Jersey, that the amendment to the Constitution of the United States proposed at the first session of the 39th Congress by a resolution of the Senate and House Representatives of the United States of America and Congress assembled to the several state legislators be in the same is hereby ratified upon the part of the legislator and made a part of the Constitution of the United States of America, said amendment being its follow word, to which Article 14. Now they're going over 14th Amendment and its section 1, section 2, section 3, section 4, section 5, where they're trying to withdraw as regards of it being ratified in 1868. Okay, it was proposed in 1866. It wasn't ratified in 1868, and they're trying to withdraw from that ratification. Okay, so they're going over the actual Article 14th Amendment, which I'm not going to read the section. I'm going to continue on. Section 1, Section 2, Section 3, Section 4, Section 5. Congress shall have the power to enforce by appropriate legislation the provision of this article. Very important, okay? So Congress has the power to enforce by appropriate legislation the provision of this article, which didn't come into ratification until 1868. The joint resolution presented by the legislator to withdraw from that ratification of the 14th Amendment in 1868, proposed in 1866. They wanted to withdraw from it based upon the language that protected free, emancipated slaves. Okay, not blacks, not Africans. Nonetheless, they were in fact emancipated slaves. So, I mean, they were free men. Okay, let's continue. So, based upon the 14th Amendment and its section 1, section 2, section 3, section 4, section 5, they go on to say, I, the legislator, be in the same is hereby rescinded, and the consent on behalf of the state of New Jersey to ratify the proposed 14th Amendment to the Constitution of the United States is hereby withdrawn. Did you hear that? In their own words, they say it is hereby withdrawn. So they didn't want to free y'all, brothers and sisters. They didn't want to. It's right there. Y'all got to give me hands up for this one. It said it right there, and a joint resolution proposed by the legislation to the legislation to not pass that legislation called the 14th Amendment. Why? Because it will be end of their fundamental government. It will be an end of their government. That's what they said in this joint resolution, which was the reason for its proposition. Let's continue. So it said, be in the same is hereby rescinded, and the consent on behalf of the state of New Jersey to ratify the proposed 14th Amendment to the Constitution of the United States is hereby withdrawn. And it be resolved that copies of the foregoing preamble and resolutions certified to by the President of the Senate and Speaker in General Assembly be forwarded to the President of the United States, the Secretary of State of the United States, to each of our senators and representatives in Congress, and to the governors of the respective states, and it be resolved that the resolutions shall take effect immediately. Okay? There is the proof. All right? In the Senate, February 19th, 1868. All right? February 19th, 1868, a joint resolution to withdraw the proposed and ratified 14th Amendment that's still on the books today. Okay? This joint resolution has been 3 times read and compared in the Senate, resolved that the same do pass by order of the Senate, H.S. Little, President of the Senate. House Assembly, February 20th, 1868. Joint resolution have been 3 times read. House of Assembly, February 20th. This joint resolution has been 3 times read and compared in the House of Assembly, resolved that the same do pass by order of the House of Assembly. A.O. Evans, Speaker of the House of Assembly. There you have it in black and white. The proof of the breach of the legal continuity of our government. There is the proof, brothers and sisters. All right. From 1868 to the present day, okay, we had no knowledge of this evidence that's now been presented to you by the king. Okay. Let's go to some more proof before I close out. Okay. Let's see what the legislature had to say about that joint resolution presented in 1868. Okay. 143 years later. Okay. 143 years later, introduced January 24th, 2002. Okay. In regards to that joint resolution presented in 1868 to withdraw from the 14th Amendment that was incorporated in New Jersey's law. Okay. Why? Because it was passed by who? New Jersey state legislator. I'll prove it as I come to my conclusion. Senate Joint Resolution number 16. If the government is helping me, why not you? Okay? That was Noble Drive. I used to say that. Sponsorship updated as of the 3rd, March 14th, 2003. Okay? So this is from 2002 or 2003. Okay? on a final joint resolution to the resolution presented by the legislation to withdraw from the ratification of the 14th Amendment in the state of New Jersey. Okay? Joint resolution revoking joint resolution number 4 of 1868, which sought to withdraw the New Jersey ratification of the 14th Amendment to the United States Constitution. Did you hear that, brothers and sisters? Did y'all hear that? A joint resolution revoking joint resolution number 4 of 1868, which sought to withdraw New Jersey's ratification of the 14th Amendment to the United States Constitution. Whereas the 14th Amendment to the United States Constitution granted citizenship to protect the civil liberties of free slaves. Did you hear that? They're only talking about free slaves. They didn't call you African. They didn't call you black. One thing they did call you were free slave, meaning that you came up under protection of the law by way of the 14th Amendment and the section of the 14th Amendment what deals with the reconstruction of your government. Okay? The fusion of government that they claimed was unlawful. Why? Because they was unlawfully took the government that was rightfully for yours. So it must be restored. It says, whereas the 14th Amendment to the United States Constitution granted censorship to protect the civil liberties of free slaves. And whereas the 14th Amendment also prohibited states from abridging the privileges or immunities of any citizen, depriving any person of life, liberty, or person without due process of the law, or denying any person of equal protection of the law. And whereas the right, brothers and sisters, whereas the rights guaranteed by the 14th Amendment are part of the foundation of our free society. Whereas in 1866, the New Jersey legislature acted to ensure these rights by ratifying the 14th Amendment and whereas thereafter, the New Jersey legislature in 1868 attempted to withdraw its ratification of this amendment by passing a joint resolution number 4. Did you hear that, brothers and sisters? How stupid can you be? Okay? We have people in-house of the legislator, the foundation of the foundation of a government, the legs that hold up the government, the legislator. Okay? The executive is the mouthpiece, and the judiciary is the hands. Okay? So it says, whereas thereafter, New Jersey legislature in 1868 attempted to withdraw that ratification that was done, as we just read. And what did it say? In 1866, the New Jersey legislature acted to ensure these rights be ratifying the 14th Amendment. The rights by ratifying the 14th Amendment. We know what ratifying means, right? To create. So in 1868, New Jersey's legislature, not the United States, New Jersey's legislature acted to ensure these rights by ratifying the 14th Amendment. And shortly thereafter, in 1868, what did they do? New Jersey legislature in 1868 attempted to withdraw its ratification of this amendment by passing a joint resolution number 4. And whereas both the federal secretary of state and Congress refused to recognize New Jersey's attempt to withdraw ratification, and the 14th Amendment became a part of the United States Constitution on July 20th, 1868. And whereas the attempt to withdraw New Jersey's ratification of the 14th Amendment is contrary to the state-long tradition of respect for and protection of the civil rights of not just black people, parts of free slaves, but anybody, okay? All right? They have a long tradition of respect for and protection of the civil rights of all persons, and whereas even those attempts to withdraw New Jersey ratification of the 14th Amendment was without effect, there is nevertheless a need to rectify this misguided action. Now, therefore, be it resolved by the Senate and General Assembly Hear me, brothers and sisters? If before enacted by the Senate and General Assembly, Section 2 of the 14th Amendment. Okay? Section 2 of the 14th Amendment. Let's get it in closing. Be it resolved by the Senate and General Assembly of the State of New Jersey, not the United States, the State of New Jersey. One, Joint Resolution number 4 of 1868, which attempted to withdraw New Jersey's ratification of the 14th Amendment, is hereby what? Revoked. Okay? Two, duly authenticated copies of the joint resolution should be transmitted to the Federal Secretary of the State, the presiding officers of Congress of the United States, and each member of New Jersey's congressional delegation. The joint resolution to take effect immediately, approved by Governor McGreevey, James E. McGreevey, 23rd of April, 2003. Okay? Very, very, very important for you to understand what was just read to you. If you don't, you are in a serious world of trouble. So in closing, we come to Second Order 14160. Okay? In closing, this is why the president is doing what he's doing. Let's read that in closing. Administration of Donald Trump 2025. Second Order 14160, protecting the meaning of values of an American citizen. Okay? They're talking about the true American citizens, brothers and sisters. By the authority vested in me as president by the Constitution and the laws of the United States of America, it is hereby ordered. We're talking about Section 2 of the United States government, okay? I'm under the 14th Amendment, Section 2 and Section 3. This is authority in which Donald Trump is acting under pursuant to the 14th Amendment based upon what he was obligated to do. By the authority vested in me as president by the Constitution and the laws of the United States of America, it is hereby ordered. Section 1, purpose. The privilege of the United States citizenship is a priceless and profound gift. The 14th Amendment states that all persons born or naturalized in the United States are subject to jurisdiction thereof, and are citizens of the United States of the states wherein they reside. The provisions rightly repudiated the Supreme Court of the United States' shameful decision in Dred Scott versus Sanford, which misinterpreted the Constitution as permanently excluding people of African descent from eligibility for the United States citizenship solely based on their race. But the 14th Amendment has never been interpreted to extend citizenship universally to everyone born within the United States. The 14th Amendment has always excluded from birthright citizenship persons who were born in the United States but not subject to jurisdiction thereof. Okay, so Donald Trump Executive Order 14160 is in compliance with the 14th Amendment, Section 1, Section 2, Section 3, Section 4, Section 5. This is the reason why in the dissent, which I'll close out, Donald Trump versus Casa, I still got it up here. Donald Trump. I didn't go over anything that I did in part one, part two, part part one and part two. But part three qualified when I went over in part one and part two. Okay? Very important. Disqualified. This is the genuine proof. Okay? Let's see, based upon Trump actions, what the Supreme Court had to say about Trump actions. Okay? In lieu of the 14th Amendment. Now I'll close out on this. Pull this case up. Come on now. So, Trump versus Costa. If it don't, I'm not gonna. I don't find it. I'm not gonna. With that being said, brothers and sisters, please understand how important it is to understand that 14th Amendment. Okay? Please understand how important it is to understand that 14th Amendment in its sections, section 1, section 2, section 3, section 4, section 5. We understand that New Jersey, which was the last state to uh, 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 ratify an act to stop slavery, but at the same time, still wanted to stay in slavery as a result of the 14th Amendment being withdrawn shortly thereafter. So with that, please understand how important this platform is to you as free people. And if want to be free people, which clearly you're not at this point in time, you must comprehend. That I'm agreeing with you as I always mean to you. That's a piece. Peace.